Good evening, class. Tonight we will discuss Title 16 of the Revised Corporation Code of the Philippines. Our topic, Investigations, Offenses, and Penalties. Our source material for this topic will be the Revised Corporation Code of the Philippines, a short introduction by Aquino and Aquino. So let's begin with the investigative power of the SEC as well as its other powers. So yung power of investigation of the SEC is found in Section 154. So yung 154, binigyan na niya ng express power ang SEC to investigate alleged violations of the Revised Corporation Code and also any rule, regulation, or order of the SEC. So, express na yung power. Although noon merong power of investigation, dito ina-express na mismo dun sa code yung power ng SEC to investigate. What else? In relation to the power of investigation, syempre, after investigating, there are findings. Now, the SEC may publish yung kanyang findings, orders, opinions, advisories, or information concerning yung violation which are relevant to the general public or other parties concerned, but always subject to the Data Privacy Act of 2012. Also, yung mga appropriate regulatory agency will be notified regarding any publication noong corporations under their regulatory jurisdiction. In addition to the power of investigation, please take note that under 155, the SEC can also perform other acts such as administration of oaths and affirmations. Number 2, it can issue subpoena and subpoena duces tecum. Please take note of these terms. Please search them also. Hindi ko na explain dito yan para mayroon naman kayong ginagawa. What else? The SEC can also take testimony in any inquiry or investigation. And number 4, SEC can perform other acts necessary to the proceedings or to the investigation. So, these are other acts which may be performed by the SEC, obviously through its designated officer. What else? SEC can also issue cease and desist orders. So, under 156. So, yung issuance ng cease and desist order, remember, is ex parte. Meaning, a hearing is not conducted. So, bakit sila mag-i-issue ng cease and desist order? To enjoin, prohibit, or to stop any act or practice which is fraudulent or can be reasonably expected to cause significant, imminent, and irreparable danger or injury to the public safety or welfare. Huwag niyong gagawin yan. Yun ang ibig sabihin ng cease and desist order. Kung ginagawa na, stop niyo yan. Yun ang ibig sabihin ng cease and desist order. Remember, before this is issued, there must be reasonable basis to believe that the person has already violated the Revised Corporation Code or at least is about to violate yung Revised Corporation Code, rule, or regulation, or order of the SEC. Now, the ex parte order is valid only for a maximum of 20 days. So, yung cease and desist na order is valid for a maximum of 20 days. Yung cease and desist order which is issued ex parte, maximum lang yan is 20 days. Now, kung nagkaroon ng hearing, due notice and hearing, yung cease and desist order may be made permanent. So, yun ang tandaan natin in 156. Also, please take note of the additional actions by the SEC. In addition to the issuance of a cease and desist order, SEC can also file administrative actions under 158, which we will discuss later on. And also yung SEC can, di ba nag-conduct sila ng sarili nilang investigation, it can transmit yung evidence to the DOJ for preliminary investigation. DOJ will file a criminal action later on if there is a violation. So, pwedeng criminal in nature yung case na ma-file in addition to the administrative actions already filed against the corporation. Take note also of the power of the SEC to cite a person in contempt. So contempt is the willful disregard or disobedience to any lawful order, decision, or subpoena issued by the SEC. So remember, any person may be cited in contempt. So what you have to remember here, class, is that yung power ng SEC to punish for contempt must be exercised on the preservative, not vindictive principle, and also on the corrective and not retaliatory idea of punishment. So please take note that the liability for contempt is after notice and hearing, fine of 30,000. If there is clear and open defiance, then a daily fine of 1,000 pesos may be imposed by the SEC. So please take note also of other administrative sanctions for violations of any provisions of the Revised Corporation Code or any order of the SEC. So pwedeng magkaroon ng fine from 5,000 to 2 million and not more than 1,000 for each day of continuing violation, but not to exceed 2 million pesos. What else? The SEC may also issue a permanent cease and desist order, which we have already discussed a while ago. SEC may also suspend or revoke the certificate of incorporation of the corporation, and it may dissolve the corporation and forfeit the assets of the corporation. What else? Please take note of the offenses and penalties, specific offenses and penalties. So yung una is yung unauthorized use of the corporate name. So remember, if a person or entities ginamit nila yung person or persons, ginamit nila yung name ng existing entities or yung name nila bigyan na lang nilang nilagyan ng corporation even though they are not corporations. So remember, if the use of a corporate name is unauthorized, punishable with a fine ranging from 10,000 to 200,000 pesos. So remember, there is a criminal liability for this one. What else? Under Section 160, so this has to do with your disqualification provision under Section 126 of the Revised Corporation Code. The penalty will be imposed on directors, trustees, or officers na alam naman nila na meron silang ground for disqualification under Section 26. Still, tumakbo pa rin sila for office as a director, trustee, or nagpa-appoint sila as officer, and they hold office or they willfully conceal yung kanilang disqualification. Why will they be disqualified? Take a look at Section 26. Pwedeng sila ay may violation ng Revised Corporation Code. Meron silang conviction or na-convict sila ng isang crime punishable by more than 6 years imprisonment, etc., etc. Balikan nyo yung ating pinag-aralan sa Title 3 ng Revised Corporation Code. So the punishment here is a fine of 10,000 to 200,000, and also in addition to that, permanently disqualified to become a director, trustee, or officer of a corporation. Hindi sinabing itong corporation lang na to kung saan siya nakaupo ngayon, basta of a corporation. So it will apply to other corporations as well. If the violation is injurious to the public, again, 20 to 400,000 pesos ang fine. What else? Section 161, there is a duty to there is a violation of the duty to maintain records and allow inspection of yung records na yan. So punishable with a fine ranging from 10,000 to 200. If injurious or detrimental to the public, 20 to 40. So this is without prejudice also to the exercise of contempt powers of the SEC. So in addition to the penalties already imposed under this section, pwede pa siyang i-contempt ng SEC. So please take note that these are the punishable acts. Failure to keep yung bylaws in the principal office of the corporation and to subject the same for inspection. Failure to keep documents, books, records such as the articles, bylaws, list of members, list of members of the board, records of all business transactions, etc., etc. Basahin nyo, nakalagay naman sa PowerPoint. and subject these books and records to inspection. So what else? Failure to keep a list of members and proxies, failure to update such list 20 days prior to the scheduled election under Section 92 in case of non-stock corporations. What else? Failure to prepare a written resolution of any action and record the same in the minutes book of a one-person corporation. So, remember sa one-person corporation, walang meeting yan. So, meron lang resolution which will be prepared. The single stockholder will sign the resolution and the resolution will be recorded in the books of the minute book of the one-person corporation in lieu of a meeting. So anyway, failure to submit yung reportorial requirements to the SEC such as the financial statement, GIS, and Director Trustee Compensation Report and Performance Report in case of corporations vested with public interest. Please also take note of Section 162. In Section 162, remember any person, so this may include also an independent auditor, any person who willfully certifies a report required under the revised code, knowing that the same contains incomplete, inaccurate, or false or misleading information, shall be punished with a fine ranging from 20,000 to 200,000 pesos. And when the wrongful certification is injurious or detrimental to the public, the auditor, sabi ko nga pwedeng independent auditor, di ba? Or any responsible person may be punished with a fine ranging from 40,000 to 400,000 pesos. Please take note also of Section 163, punishable acts in case of independent auditor collusion. So, remember in 163, yung independent auditor is in connivance or collusion with directors or representative of the corporation. Anong ibig sabihin nito? Collusion, ibig sabihin nagsasabwatan sila. So, yung independent auditor na to certifies yung corporation's financial statements even if the financial statements are incomplete or inaccurate and there is failure to give a fair and accurate presentation of the corporation's financial condition. So, sinertify niya kahit na alam niyang mayroong false or misleading statements. Yung financial statement ng corporation, the fine is, remember, 80 to 500,000 and if the fraudulent report is as certified will cause injury to the general public, the fine is 100,000 to 600,000 pesos. So remember, ang magsasuffer ng penalty dito is yung independent auditor, director, or representative of the corporation na nagsabwatan. So, what else? Registration through fraud is also punishable. Gagamit ka ng fraud para makapag-register. The punishment is imposed on the people who are responsible for the formation of the corporation or even those who assisted. Fine is 200,000 to 2 billion if detrimental to the public, 400 to 5 million pesos. What else? Fraudulent conduct of business under 165. So, yung business is conducted through fraud. So, fine is 200,000 to 2 million if injurious or detrimental to the public, 400,000 to 5 million pesos. Also, class if a corporation, the corporate vessel is used for fraud or to commit graft and corrupt practices. Remember, the fine is 100,000 to 5 million. So, yung mga employees, directors, officers, kung sila yung engaged in graft and corruption practices and there's a failure on the part of the corporation to install safety measures para magkaroon ng transparency dun sa corporation, remember class, this will be prima facie evidence of corporate liability. So, kung hindi naman yung corporation ang ginamit as an intermediary for graft and corruption, pwedeng third person naman. So, the corporation will engage a third person as or appoint as a third person as an intermediary who will engage in graft and corrupt practices. So the fine is, remember here, 100,000 to 1 million pesos. So in 166, yung corporation ang gagamitin for fraud and graft and corruption. In 167, yung corporation kumuha siya ng ibang tao para who engages in graft and corrupt practices. Para sa corporation, tulungan nyo ako mag-evade ng tax, tulungan nyo ako mag-ganito. So, the fine is higher actually. So, 100,000 to 1 million pesos. The range is higher. What else? If the corporation tolerates graft and corrupt practices of its directors, trustees, or officers, remember yung mga directors, trustees, and officers na nag-tolerate such action. Alam naman nila na merong ganyan pero hindi sila nag-report. Remember, punishable with a fine ranging from 500,000 to 1 million. So, kailangan mag-report kayo, kailangan medyo sumbungera kayo. So, anyway, itong mga sumbungera, tawag sa kanila, whistleblower. So, a whistleblower, remember, is any person who provides truthful information relating to the commission or possible commission of any offense or violation under the revised corporation code. This is not a new concept, class. I'm sure na rinig nyo na to. Yung mga whistleblower sa mga scandal yan. So, sila yung nagiging witness. Usually, there's an inquiry by the Senate, etc., etc. So, anyway, the revised corporation code, pinoprotect nila yung mga whistleblowers. So, kung you cause any act which is parang intended to retaliate or take revenge against a whistleblower or commit an act detrimental to the whistleblower, ikaw ang mapaparusahan. Anong mga example ng acts detrimental to the whistleblower? Interfering with lawful employment or livelihood ng whistleblower. Tanggalin mo siya sa trabaho, babaan mo yung sweldo niya, i-demote mo siya, etc., etc. Ito yung mga acts detrimental to the whistleblower. Bawal daw yan. Pinoprotect kasi sila ng revised corporation code because they provide useful information dun sa investigation ng SEC. Anyway, fine is 100 to 1 million pesos. 100,000 to 1 million pesos. Take note also of the catch-all provision of the revised corporation code of the Philippines found under section 170. This is similar, class, to yung section 144 of the corporation code. But remember, section 144 of the corporation code has already been declared by the Supreme Court as suffering from textual ambiguity. Meaning, malabo yung section 144. However, kahit malabo yung section 144, this was not corrected and instead this was adopted under section 170 of the revised corporation code of the Philippines. Sabi ng Supreme Court, yung section 144 only has utility or use if there are provisions in the corporation code that specify consequences other than penal or criminal for violation of or non-compliance with the provisions of the earlier corporation code. So again, up to now, it is not clear which violation of the other provisions of the revised corporation code makes the person who commits the violation criminally liable. So it does not actually refer to a specific violation. Hindi malinaw kung ano talaga yung violations na nako-commit. But anyway, section 170 is a general provision for violations on top of other provisions on specific violations. So kaya nga siya tinawag na catch-all. Anyway, violations which are not otherwise penalized under the revised corporation code will be punishable by a fine of not less than 10,000 to 1 million pesos. So if the violation is committed by a corporation after notice and hearing, it can also be dissolved by the SEC. And even if the corporation is dissolved, it does not prevent the filing of any action against the director, trustee, or officer of the corporation who is responsible. So under the provision, under this provision, Section 170, the liability is still separate from other administrative, civil, or criminal liability under the law. So please take note also of the liability of corporations under Section 171. So under the provision, if the corporation is the offender, the liability may be imposed on directors, trustees, stockholders, members, officers, or employees subject to the discretion of the court. Also, aiders and abettors are secondarily liable. So the fine of the aiders and abettors will not exceed that of the principal offenders at the discretion of the court. The court will also take account of the participation in the offense. So anyway, that ends Title 16 of the Revised Corporation Code. Please stand by for Title 17, the last title. Thank you and good night, class.